All right, welcome to the Credit and Collection News Podcast. My name is Steve Ruderman, recording here from the lovely island of Maui, where I happen to be located today. We are really honored today to have someone who's been in the industry, we'll just say a long time, but I know he's been with Ballard Spahr for about 30 years, from partner to senior counsel. He is the expert on the CFPB. He's been looking and monitoring, helping creditors out, and trying to interpret all the rules and regs of the CFPB, which changes, let's just say, on a daily basis of what's happening in the credit and collections industry. Um, Alan, I know, has spoken at some of our conferences in the past. He's definitely well known throughout the industry. So, Alan, welcome from one beach to the other.
Yes, well, Steve, my pleasure to join today. It's really fun to be as a guest on a podcast show as opposed to a host. So I'm very much looking forward to it.
Fantastic. Like I said, it's always great to have an expert here. So I don't have to talk. I can just sit back and listen and enjoy everything that's there. So no, not that there's any pressure on you, but yeah, we're going to put all the pressure on you. Um, in talking about the CFPB, and the CFPB is always they're running in our headlines 3 to 4 times a week. They're either the number one or number two top article with everything that's going on in the industry, whether it's an enforcement action or a new rule and stuff. But even today, the CFPB issued the proposed interpretive rule regarding earned wage access, which, like I said, literally just came out today. Let's talk a little bit about the CFPB, and I know there's a lot of topics to go over, but just talking maybe a little bit about the earned wage access, and maybe a little bit about what's going on with the Supreme Court and the CFPB. I mean, I know the Supreme Court said they are funded constitutionally, but there's some claims about are they losing money? Can they be funded by the Federal Reserve since they are? There's lots of things. So let's talk a little bit about that, and we'll just kind of work through some of the stuff, and let's go from there.
Well, sounds good to me, Steve. Why don't we start with at the high level of talking about the CFPB, the agency itself. And as your listeners are well aware, the Supreme Court not too long ago, actually was on, I think, June 16th, came down with a long-awaited opinion in CFSA versus CFPB, which dealt with the issue of whether or not the funding mechanism that Congress had created for the CFPB and Dodd-Frank, whether that ran afoul of the appropriations clause in the Constitution. The CFSA and a lot of people in the industry, although not all of them, but I'd say a good many of them, were of the view that the appropriations, the funding mechanism used by Congress was unconstitutional. And what the funding mechanism did is it avoided the CFPB having to go hat in hand each year to Congress to get a annual appropriation. And instead, it said it could request money or funding to pay expenses from the Federal Reserve Board up to a certain cap that got established that could be increased in each year based on inflation. But it said very specifically that the funds paid by the Federal Reserve should come out of the earnings of the Federal Reserve System. Now, in the case that got decided on June 16th, there was no need to focus on what I'm going to call the second potential constitutional defect of the CFPB. All they were focused on was whether or not, assuming that there were sufficient earnings of the Federal Reserve System, was it okay to do an end run around Congress, not have to go for appropriations each year, but instead just make a request to the Fed, either on a quarterly basis or an annual basis, for funding that it would need for a future period of time. All right, so 7-2 vote. The Supreme Court decided that the mechanism was constitutional, that there was nothing, as long as Congress specified a source of the funds and how the funds would be used, that was sufficient. And there was no need for an agency to go to Congress. It was pretty clear to me after listening to the oral argument that's the way they were going to come out. And frankly, I think they came out that way because they were really scared that if they had come out the other way, it would jeopardize the legality of a lot of other federal agencies who were not funded identically to the CFPB, but in a manner that was somewhat analogous, like the post office. It's self-funded. It has lots of revenues it generates from the sale of stamps and other services, the comptroller of the currency. It's funded by assessments to national banks that are supervised by the comptroller and the Federal Reserve Board itself. They don't get any money from Congress. They, in fact, at least until recently, they were a generator of revenues. That is, the Federal Reserve banks, of which there are 12, and it's known collectively as the Federal Reserve System. They always made a lot of money each year. It was in the billions and billions of dollars. And so when Congress passed Dodd-Frank on July 21, 2010, there was no concern at all about whether the Fed would ever get to a state where it was losing money. Nobody thought about that for 1 minute, one iota, but they put that language in Dodd-Frank. They never thought that was going to come back to haunt them. And boy, has that come back to haunt them. Because beginning in September of 2022, the Federal Reserve stopped generating profits, and they started losing money, but losing money hand over fist. I mean, in the billions and billions of dollars, and it kept getting worse as interest rates kept going up. And they're still losing a ton of money today. And the only thing that will eventually, hopefully, get the Federal Reserve into a positive situation where it's generating profits again is if interest rates start coming down and come down pretty rapidly. But anyway, so you look at the language in Dodd-Frank, and it says the CFPB can be funded out of earnings of the Federal Reserve System, combined earnings. Well, to me, Steve, earnings means profits, right? That's right. It means the same thing as net income. But when this issue got raised, first of all, by Professor Emeritus Hal Scott, who wrote on June 20th an op-ed in the Wall Street Journal laying out this position that the Fed should have stopped sending money to the CFPB when it started losing money back in September of 2022. And it continued to ignore the language of Dodd-Frank, and it keeps sending money to the CFPB. Then there was an article written by Alex Pollock, an article that appeared on a website of the Federalist Society. I picked up on it, and I have written several blogs. While I am a lawyer at Ballard Spahr, I launched our blog back on the very day the CFPB got stood up, by the way, which was July 21, 2011. And I have really gone after that, digging into that issue. And we've done some podcasts about it. And it's really a problem. And so far, Rohit Chopra, the director of the CFPB, just wants to ignore it. I guess denial is the first stage, right? That's the first thing. He's in denial.
Especially in government, yes.
Yeah, I mean, he had came for his annual or semi-annual hearing before the House Financial Services Committee and the Senate Finance Committee. A couple of Republicans asked him about it, and his answer was sort of an ipse dixit. For those of you that know Latin, there was no reasoning at all. That he just said there's no problem there. We've looked into it. There's no problem, but he didn't get into any detail, and unfortunately, the people on the senators and the congressmen, I felt, didn't push him hard enough. But that is a major cloud hanging over the CFPB. Still, that's not as significant as the last constitutional problem, which could have affected literally anything that they did going back to when they started operating. This affects anything after September 2022. So any regulations that have been issued after that time, any enforcement cloud hanging over it. But interestingly enough, Steve, so far the issue hasn't been raised in a court proceeding, and still waiting for that to happen. I think it's inevitable, but it hasn't been raised yet. So anyway, that's the 25,000-foot view of the CFPB, where it is a real issue. And then, of course, I know later on we're going to talk a little bit about the potential effect of the election on the CFPB. So we'll get to the election at some later point before we're done. But let's talk a little bit about earned wage access, because you mentioned that, and there's so much to cover. I'm not going to really get into the weeds here, but earned wage access is something that the CFPB has been aware of for ever since the product basically launched. And it was a product that was intended in a way to be a substitute for payday loans. The payday lending industry largely, I won't say disappeared, but was no longer as significant a factor in making short-term loans to people that have less than stellar credit. But with respect to earned wage access, as I'm sure most of your listeners know, it's a way for employees to get paid for work that they've done and not have to wait until usually they get paid every 2 weeks, bi-weekly paycheck, and they get paid in arrears. It's a way to get money earlier that you can use to better match your expenses, with the revenue that you have coming in. Well, anyway, a few years ago, they seemed to be fairly receptive to this product. I mean, this is really a really good product in the sense that it's not a loan, and they typically, the employee or the consumer doesn't pay interest on the transaction, but they are able to get funds in advance of their paycheck, and then it gets paid back usually automatically out of their paycheck. And it's a much lower, first of all, there is no interest that's charged. There is sometimes are fees. If somebody doesn't pay on time, they would pay a late fee typically. But anyway, really good product. CFPB issued an interpretive letter for one company a long time ago where they agreed it wasn't a loan. But then things started happening. It's so often the case with the CFPB. Uh, Anything that appears to be something that the industry likes, Rohit Chopra has got to figure out there's got to be something wrong with it. And sure enough, today he came out with an interpretive letter, did a complete 180. The old letter that got issued a few years ago out the window. It's now a loan. And even though there may be sometimes the only revenue that the lender might get would be a tip, which is a voluntary tip. It's not, you're never obligated to give a tip. But they decided that essentially any kind of anything that gets paid by the consumer to the lender is going to be considered a finance charge, and it's subject, not, they can't with state usury laws because that's not their bailiwick, but it's subject to the Truth in Lending Act, and you've got to give truth in lending type disclosures. Well, that's the issue today. That's just one day. Every day there's something else going on. If it isn't earned wage access, it's buy now, pay later, it's credit card late fees, it's everything. There isn't a sector of the consumer finance industry that goes untouched by Director Chopra. I've been talking for too long, so Steve, I'm sure you've got a lot of other things you want to hit me with. So I'm ready to to deal with some other issues.
Well, that was one of the reasons we had you on, and we narrowed the topics down to, like I said, the CFPB, because there is so much going on,
Right.
and that's something that happens. And you kind of hit a couple ones right there in at the very end when you're talking about the late fee rule of the $8, and there were so many interpretations of that. How is the $8? How do they derive the $8? How do they get to that? Is that a reasonable expectation? Can they get to that number? Can they show the reasons why they got to $8? And we've heard from industry folks that are saying no, that the $8 was just kind of an arbitrary number that they threw it against the wall, and that's kind of it's there. And there's been no comeback that says that there. Or you mentioned also the buy now pay later rules, which again didn't seem to be under the CFPB until the CFPB said, no, I think that's under us. And we can certainly, make our comments and say what has to be, covered by the CFPB. So let's kind of grab at both of those. I mean, we haven't even
Yeah,
talked about enforcement actions or anything like
yeah,
that, but
yeah,
let's kind of
yeah.
run at that one for a few minutes.
Okay. Well, the credit card late fee regulation is a good topic to talk about. So, um, if you roll back the clock to actually before the CFPB even got created, the Federal Reserve Board had jurisdiction under under the Truth in Lending Act, and it dealt with most of the consumer finance regulations at the federal level. So there was an act called the Card Act, which amended the Truth in Lending Act when the Fed was in power, and one of the provisions in it said that late fees had to be reasonable and proportionate to the costs of a consumer being delinquent on his or her credit card account. So eventually, jurisdiction transferred from the Federal Reserve to the CFPB, and the CFPB continued that regulation, and it essentially allowed a credit card issuer to charge $41 in the way of a late fee for the first delinquent payment, and then subsequent delinquent monthly payments, yeah, they could assess $30. And there was also a provision in the regulations that allowed the credit card issuer to adjust it every year for cost of living, for inflation. And so the numbers initially were less than $41 and $30, but they eventually got up to that level. Well, not surprisingly, Rohit Chopra thought that those late fees were way too high, way too high. Well, and he proposed to reduce them to a flat $8, no cost of living adjustment at all. And that was quite a steep decline. One of the major concerns from the industry was that it would there'd no longer be a deterrent effect. An $8 late fee is almost like just the cost of doing business. If you've got a choice, you've got a late credit card bill, and you're only going to have to pay an $8 late fee, or you've got a mortgage and a car loan, and you've got other expenses, you're going to put that credit card bill at the bottom of the pile, and you probably aren't going to pay it that month, and you'll pay $8, and maybe you'll even continue that for a couple of months. Well, anyway, the industry did what at the time was somewhat unusual, but it's turned out not to be so unusual. They sued the CFPB, and they brought the lawsuit in a hospitable forum in the Northern District of Texas in federal court, the Fort Worth Division, and the case got assigned to Judge Pittman, who was an appointee of Trump, and he's one of many conservative judges, many Trump appointees in the Northern District of Texas. The lawsuit got filed. Everybody was sort of counting their chickens before they hatched, because the one thing that really surprised everyone is that he didn't really want to keep the case. And he had serious doubt. I'm talking about Judge Pittman now, whether there was venue in front of his Fort Worth Division of the Northern District of Georgia, given that the CFPB is located up in Washington, D.C. The trade associations that brought the lawsuit, two of them, there were, I think, three altogether, the American Bankers Association, Consumer Bankers Association, based up in D.C., and there weren't, maybe there was one lender that was a member of a local trade association, a local chamber of commerce, that was even affected by the credit card rule, because the credit card rule only applies to the largest credit card issuers. It doesn't apply to small credit card issuers. Well, anyway, this judge just went out of his way to transfer the case to the district court in the District of Columbia. That would have been pretty bad if that had happened. A totally different, it would have been a federal judge, I think appointed by President Obama, known for being somewhat progressive and liberal. Would have changed the game altogether. But what Judge Pittman didn't realize is that the Fifth Circuit Court of Appeals didn't like what he was doing. And so, to make a long story short, twice Judge Pittman transferred venue to D.C., and twice through an extraordinary, what's called a petition for a writ of mandamus, not an appeal, because you can't technically appeal an order transferring venue. But they filed this mandamus petition in the Fifth Circuit. Fifth Circuit granted it and twice it got sent back to Judge Pittman, and they told Judge Pittman to reverse the order transferring the case. Well, believe it or not, this happened just today as well. The district court now has the case again. It's been sent back to him, and the CFPB today filed a motion to dissolve the preliminary injunction. Preliminary injunction was issued based on the Supreme Court decision in CFSA. But once that opinion came down on June 16th, that ended up reversing the Fifth Circuit, and there was no longer a basis for maintaining an injunction based on the constitutional issue dealing with funding. And then the other thing they did, which came out of the blue, was they renewed their motion to transfer venue now for the third time. And they claimed that the district court, when it originally transferred venue, it relied on a certain provision of a federal statute, but there was another provision of the same federal statute that it didn't deal with. And they've now asked Judge Pittman to transfer venue again, or in the alternative, dissolve the motion for preliminary injunction. So we're still in this state of limbo, Steve. Now, the industry, of course, is going to, very soon, say to Judge Pittman, enough's enough, third time isn't a charm.
Right.
It's enough with the transferring venue. And with the respect to the preliminary injunction, you've got to keep that in place because we have other alternative arguments that were put on hold that you never dealt with, Judge Pittman, waiting for the Supreme Court to deal with the constitutional issue. And one of the arguments is based on the Card Act, and it's the argument that you articulated, Steve, when you asked the question, and that is, where'd they come up with the $8? Where did that come from? And they've never, CFPB has never shared that information. They claim they can't share it, that it's in confidential filings made by a number of bank holding companies whose subsidiary banks issue credit cards. But that now has been teed up. And there's another issue that is with respect to timing that even if they had a right to reduce the late fee to $8, they didn't have the right to establish an effective date so close to when they issued the final regulation. That issue also is in front of the court. That's under the Truth in Lending Act. And those issues are now finally going to get litigated. If the case stays in front of Judge Pittman, either he denies the motion to transfer, or if he grants it, you can be sure the industry will go back to the Fifth Circuit and say, we're back, reversed this again, so we can finally get to the merits of the case. And I think eventually Judge Pittman will decide the case. I think he is going to decide in favor of the industry. And that will be a very nice win for the industry. Now, the other thing you mentioned, buy now, pay later, which has become a very popular product. Also, like earned wage access, one of these newer products that's something that we didn't have the technology 10 years ago to offer a product like this. But it's an alternative. Somebody goes into a store to buy something, a TV or electronics or anything. They can use the credit card, but very often they can agree to a buy now, pay later transaction where they will put a certain amount of money down, and then there will be three installments, that will be paid. In addition to that, no interest, ever gets charged. Again, one of these things, very consumer friendly product. Everybody except the CFPB thought this was a good deal for everybody, a win
Right,
win
right.
win. It's no. Rohit Chopra, very not so long ago, just a few weeks ago, decided that it's really like a credit card. It just it's like a certain type of credit card, and he shoehorned buy now, pay later into the Truth in Lending Act and is requiring the same kinds of disclosures and requirements that apply to credit card issuers. And the fact that they're not charging interest means that there's certain portions of the Truth in Lending Act that won't apply. But if there are a lot of credit cards where you can't revolve, where you've got to pay the monthly amount, whatever you owe that month. And he analogized it to that product. Now, fortunately for CFPB, they haven't been sued regarding that product, at least as yet, which to me was somewhat of a surprise because it really, I think, is a stretch what Director Chopra did. And now, particularly with the Supreme Court opinion coming down at the very end of the term that overruled the Chevron deference
Right.
doctrine,
Absolutely.
there's no longer a need to defer to a regulation or an interpretation by a federal agency. And now the courts can just look at what the agency did and listen to all the other arguments and just on its own decide, who should win. So buy now, pay later. Maybe there won't be a lawsuit. I don't know. I think the industry is starting to get a little weary in filing so many lawsuits, even though the track record is extremely good so far.
Right. Well, let's talk about this because even with the Chevron doctrine coming down, we're getting into we talked about this a little bit earlier, election season.
Yeah.
We don't call it election day anymore. We call it election season because we have, the early voting and stuff like that. So although we have 4 months before the actual election day, right now the trend is Trump is ahead of Biden or whomever will be running. I don't know if that's going to change this weekend, if it's going to change next week, if it's not going to change at all. But right now the numbers show Trump ahead. And then you've got obviously the Democrats are kind of in a defensive position in the Senate. Again, the way the elections work every so many years. Last time the Republicans were in the defensive, now the Democrats are. So you're looking at that. You're also looking at the House. But if everything goes red, there's a good chance that you're going to have a change of leadership at the CFPB. And if that happens, I mean, a lot of this stuff, does it change? Does it go a different direction? Who comes in? We talked with Kathy Kreninger on this podcast last week, and some of the things that she was talking about. She'd been working in government for decades. And under different administrations, whether she was in the Senate or working for the House, and she was very, under the Obama administration, under the Trump administration, now everything's very divisive. So what's going to happen to the CFPB and it's still an if, you don't know, you can't predict elections and God knows it changes on a minute by minute basis of what's happening in the news. But, what happens to the CFPB, especially if, it's not a 5-person panel. It's a 1-person show. So what do you think?
Well, okay, there's a lot there to unpack, but let me try. First of all, let me say at the outset, I am not a politician. I am not an expert in politics at all. I have no idea who's going to win the election, and I'm not going to share with you or your listeners who I intend to vote for. I'm only going to look at this as objectively as I can as to what I think is going to happen. Now, you said at the beginning, if Trump should win and the House and Senate also become red, that Chopra's out of a job. Well, it's worse than that for Chopra. In other words, the House and Senate could remain Democratic, but if Trump gets elected, you can be sure one of the first things he's going to do is get rid of Chopra and install somebody there as an acting director until he can get somebody confirmed by the Senate. We need only look at was a different situation during the first Trump term because then there was uncertainty whether Trump could fire Richard Cordray, the then director of the CFPB, without cause. And there was language in the Dodd-Frank Act that said the president can only get rid of the director of the CFPB for good cause. The Supreme Court in the Seal of Law case said that was unconstitutional. You can't hamper the president in terms of getting rid of the director of the CFPB. The president's has to have the right to remove the CFPB for good cause, no cause at all, any reason at all. So Trump will get rid of Chopra. He would get sworn in, I guess, on January 20th. I would guess he'd be gone that afternoon or the next day, or maybe he decides to resign sometime between the election and the inauguration. In any event, whoever, if it is Trump that wins, he'll appoint somebody very conservative, someone who I'm sure would not be considered a friend of the CFPB. Now, originally, you remember in his first term, he appointed Mick Mulvaney, who was at least at the time, a very loyal Republican conservative guy, former congressman, and he took charge of the CFPB until Kathy Kraninger got appointed by Trump and got confirmed by the Senate. So he will he'll be gone. There'll be new leadership there. You can be sure that the new leader, whoever it might be, is going to take a look at everything that's pending. There are essentially three things that the CFPB does. If you want to, look at it in some kind of an organized fashion, they issue regulations. They regulate. Sometimes they're not formal regulations. Sometimes they give different names to them: circulars, opinion letters, blogs, speeches. There are all kinds of things that they do. But that's one of the first things that you can be sure a new director is going to look at. And to the extent that there are things that are only proposed and haven't been finalized, one would think they would be put on a very slow track and probably never get finalized. So we're talking about things like the overdraft fee regulation, which would apply to banks, NSF fees that are charged by banks, a new larger participant rule that would apply to companies that maintain electronic wallets. And there are many, many other things that are in the pipeline at the CFPB. And if they haven't been finalized already, I don't think they're going to get finalized. Probably none of them. Then they'll look at the litigation, if it's still pending, challenging the regs, and they may decide to throw in the towel. They don't have to continue to litigate anything. They could decide they've changed their mind. It's one thing they could do, or they could do what Kathy Kraninger did with the payday lending rule. She proposed a new rule to repeal the ability to repay language, but she kept in one section of the payday lending rule that says that you can't, if the customer tries to pay electronically and there isn't money in the customer's account to make the payment on the payday loan, you can do that twice. But if you want to try it a third time, you got to get something in writing from the customer at that time authorizing you to present the payment, the item again for payment. So that could happen. I mean, they could decide to look at the late fee rule, assuming it's not already been rejected, and decide to change the rule. But if they do that, with respect to final rules, they can't just wave a magic wand. They and say, poof, the rule is gone. They have to actually propose a new regulation repealing the existing rule. And they have to propose that for comment and jump through all the same hoops that you would need to jump through if you were promulgating a regulation for the first time. So that the late fee rule certainly will be gone. My guess is the rule that pertains to data collection related to small business loans made to women that are owned by women, or companies that are owned by women or other minority groups. There's a regulation there where the CFPB went a little bit overboard in terms of the data that it was going to require the lender to collect. And that's being challenged in court right now. And so far, CFPB is losing, but who knows how it'll eventually turn out. But the new director of the CFPB would have the right. They have to issue some kind of regulation, but not the regulation that Rohit Chopra decided to issue, because there's something in Dodd-Frank that requires the CFPB to issue that regulation. So everything will be looked at very, very carefully, and it will be looked at not only from a consumer point of view, but from an industry point of view. Are there things here where Rohit Chopra went too far, and it could be cut back? So that's the regulation part of it. Then, with respect to enforcement, they will look at all pending enforcement actions. I don't know how many there are, maybe 20, 25 that are pending, that were stayed while the case is pending in front of the Supreme Court, CFS case. But now they're moving again, now that case has been resolved. And I'm not saying he's going to just drop cases willy-nilly, but there probably will be a fire sale to settle cases that aren't very good and aren't very strong. Cases that represent out and out fraud, they're going to be a problem under any director. Nobody is going to, no, and Kathy Kraninger is a great example of that. She didn't just, decide to get rid of all the cases and never file another enforcement case, but she focused more on the things that were really bad, that were out and out fraud, scams, and a number against debt relief companies, fly-by-night companies. They They were given no safe harbor by Kathy Kraninger, and they won't, I don't think, by the new director. But you won't see the pushing of the envelope, the bringing lawsuits where the law isn't so clear that the CFPB's got authority or has jurisdiction over a certain type of company or a certain type of claim. I would expect those cases, what's out there, will go away pretty quickly, and they won't file any new cases where they are pushing the envelope. Then the one thing that probably remains pretty steady throughout the process is supervision. They will still continue to conduct examinations. There is going to be the examiners aren't all of a sudden going to leave. They're going to be there, and they will work for whoever the new acting director or director is, and they will do their job. And if they see things that are violations of law, they will write you up for that, and you may have to deal with it at some point. Now, let's talk about the big enchilada. That is structural changes at the CFPB. That will only happen, in my view, if if you have a Republican president, and if you've got a Republican House and a filibuster-proof majority in the Senate, meaning there are 60 or more Republicans in the Senate. Unless, sometimes you can get a few Democratic votes, but you can't count on that.
Right.
They've been talking about ever since the CFPB got created that we need to make changes. It's not right that one
One
individual
person.
has that much power, regardless of whether the individual is a Republican or a Democrat. We've seen it on both sides. We've seen the leadership change. Regardless, it should have been done as a 5-member commission, bipartisan commission, similar to the Federal Trade Commission. But that's not how it happened. In 2010, consumer finance industry didn't have a lot of leverage with Congress. Let's put it that way. We had just been through the recession of 2008, 2009, and it was blamed on the federal agencies, the banking agencies, for doing a bad job. And it became necessary in the eyes of certainly all Democrats led by Elizabeth Warren, but even Republicans, some Republicans, there was a need for a new agency, and we had to insulate that agency from political pressure. So one of the things we do is we don't subject them to annual appropriations from Congress. They
Right.
get their money from the Fed. Another thing we do, we have one leader. We have one person it's got power, and they were hoping that person couldn't even be fired by the president except for cause. Well, now that person can be fired by the president at any time without cause. A 5-member panel or commission, I don't see that happening unless the Republicans have got 60 votes or more in the Senate. They control the House, and it's the Republican president. Then they can do that. I don't think they would eliminate the CFPB altogether, because politically, that may not be a wise move. And one other thing to throw into the equation, not that I think it's controlling, the vice presidential pick of Trump, J.D. Vance, he's known as a populist, right? And,
Right.
you look at his background, I don't know where he stands on the CFPB. He very well may think they're a great agency and doing a good job. And I think Trump, will obviously have the final say in terms of what the policy of the administration will be. But I think it's even if it's a red avalanche or a tsunami. I think it's still going to be very hard for the Republicans to get a filibuster-proof majority in the Senate. But if they do, changes will be made for sure.
Yeah, I agree with you. I don't think I mean, I just don't see it happening. At least not right now, the way the numbers are looking and the pollsters. I think at our conferences, one of the speakers we usually always have is Larry Parks, who's an economist and he focuses on politics. And he analyzes the numbers and can say who's who's going to win and who's there. And his at our last conference, he was talking about the trends and where they're going, and that was back in April. So of course things have changed dramatically in that realm, and we're going to have him at our consortium coming up before the November election, probably in October. But when he speaks, he'll kind of address that issue, and I don't think there's enough swing. There's I don't. We'll probably see at this point from this day. I would say it's going to go red, just because the analysis says that way. But one thing between now and November, he always says three things will happen. And you know what? Those three things can completely change an election and do it. But as he said 4 years ago, he said that it was Biden's election to lose. They kept him, off the circuit, and thus he didn't. 8 years ago, he actually said the numbers said Trump would win, which got an interesting response from the group at the consortium, because the consortium said I think it was leaning a little toward the red, but even they didn't believe him because they were like, no, this was in September before the November election, and they all thought he was crazy. They said there's no way that Trump can win. Of course,
Right.
Trump did win, but he said his numbers do that. So he's the expert. I'll defer to him.
Yep.
We will have him back speaking at our conference, our consortium before the election, so everyone can kind of get their feel as to which way the election's going to go. But my feelings are, yeah, you're going to get a red Senate, but you're not going to get a filibuster-proof Senate. You're probably going to get a 1 to 2, senator swing. Should be enough to get them back in charge, but that's not enough to get them to, change Washington. Not and again, that's my prediction. I'm not the expert. Larry is, so they'll have to come to the consortium to hear that to find out. But the swing to a 5-person panel versus the one person in charge would change a lot of things at the CFPB. So, I mean, the FTC has always been known as an enforcement group. I mean, they go in and they go after what I would call the bad players in the world. They're not
Yeah.
after the the rules and regs. They're more, if you violate the rules, the
Yeah.
FTC comes in and comes after you, which again, maybe that was the intentions of the CFPB originally, but that turned into, like I said, to where they are now, which is completely different.
Well, and
um,
the thing is, Steve, you got a five-member commission. It slows things down. Things become more deliberative. There's more debate that goes on with the CFPB. It's one individual, and there's something he doesn't like. He says, "Oh, I'll issue a regulation banning it. I'll call it an unfair, deceptive, or abusive act or practice." I mean, it's unbelievable. There's one thing I just somebody mentioned. I know we're getting near the end of the program today, but this is really an important thing, and I think a lot of people, including people in the industry, haven't really focused in on this yet. He issued not a regulation, but a circular very recently where he said it's a unfair or abusive act or practice if you draft a consumer contract and there's language in the contract that is contrary to state or local or federal law in any fashion. Well, and he also went on to say you can't use you can't protect yourself by putting in what I'll call prefatory language that says something like, except where prohibited by law, you know, the lender shall be able to do the following. Can't do that anymore. Well, guess what? The FHA and the VA and the Department of Education and Fannie Mae and Freddie Mac are going to have to revise all of their contracts, as well as the entire industry. We've been engaged by several clients to bring their contracts into compliance with this circular. And I haven't yet found a contract that doesn't have to be revised. Well, you know what the cost of that is going to be? And no.
I would toss out $8, but I think that's not the.
Yeah,
Sorry, it's
yeah,
just a little. I had to throw that in there just for fun. But
yeah,
yeah, no,
yeah.
I know what you're saying.
Oh, and obviously he did this as a circular. He knew he wouldn't be able to justify the cost of doing this as a regulation. It hasn't been proven that there's any need for this kind of a review of every contract. But it's there, and it's effective already. And slowly but surely, clients of mine and others are realizing what's ahead of them. And, probably that circular goes away if there's a new director of the CFPB in January. But do you count on that? I mean, I don't know.
Yeah,
That's not
that's
usually a good, usually something you don't want to roll the dice and bet your company on who's going to win an election, right?
no. It's too iffy, and that's crystal ball because you're,
Right.
if you're hoping for something to happen, it usually doesn't. So that's that's always where you kind of look at from that standpoint.
Yeah.
With that being said, Alan, I want to thank you for your time. This was fascinating as always. Anytime I can sit down and listen to what you have to say is there. Um, if you like this on the podcast, come to the conferences because that's what our conferences are all about. We love to have people like Alan come talk about the industry and what you need to do and to help you understand the industry there. So, Alan, love to have you at the consortium and have you at our conference. The consortium will probably be in Texas in sometime in I believe October is what we're looking at, finalizing that now. And then the
Yeah.
conference next year in 2025, we're looking at Florida, coming to the East Coast. We were on the West Coast last year, so kind of rotating the coast over to the
I
East
know
side.
Maui looks pretty good. You sure you can have Maui?
Yeah. As much as I would love to have everybody come here to Maui, it would be it's a little expensive, and it's a definite hard one to walk into your boss's office and say, "Hey, I found the conference that I really think I need to go to," and then they say, "Where's it at?" You say Maui. Usually the boss will say, "You know what? I think that's the one I need to go to, not
Right.
you." And that's so yeah,
Or you
there's
can attend it virtually, can't you?
yeah. So that's another tough one. So as much as I
Yeah.
love the 50th state and all that, yeah, that's a hard sell to get people to get permission to
Yeah.
do that.
Got it.
So that's what we're looking at. But like I said, thank you for taking the time. Thank you for coming on. It's been fascinating. And like I said, love to have you at our shows, and we'll talk about that off. I won't put the
Yeah.
pressure on you right now for an answer, but we definitely there. If you like the
Well,
podcast, the speakers on the podcast that we bring on are definitely the same folks that we like to have to the conferences
right.
and speak because this is the hottest topics in the industry, and you guys are the people that need to be talking about it because, like you said, you don't want a crystal ball.
Right.
You want to look at the facts. You want to look at what you're there, and you want to make an informed decision as to what's happening. And I mean, what we hit is just the tip of the iceberg.
Mm.
Just on the CFPB, we haven't talked about any of the other regulators, whether it be the FTC, the OCC. I mean, and then of course there's every state out there that has their own, from California with their own mini CFPB, the DFPI. It goes on and on and on, which this podcast could turn into a 17-hour, show, which I don't think anybody,
No.
including myself, would
Right.
would watch. So that with that, we'll say
Well,
again, thank you.
well, thank you, Steve. It was really a pleasure, and I very much enjoyed chatting with you today, and hope that the information that I imparted will be helpful to your many listeners.
It definitely will. And with that, we're going to go ahead and say thank you again. And from that point, uh, stay tuned for our
Yep.
next Credit and Collection News podcast, which will be coming out real soon.